Heirs of Ureta versus Heirs of Liberato Ureta, GR number 165748, September 14, 2011. Topic: Article 1346 of the Civil Code. The facts. Francisco, who was then a municipal judge, suggested that in order to reduce the inheritance taxes, their father should make it appear that he had sold some of his lands to his children. Accordingly, Alfonso executed 4 deeds of sale covering several parcels of lands in favor of his children, Policronio, Liberato, Prudencia, and his common-law wife, Valeriana de la Cruz. On April 19, 1989, Alfonso's heirs executed a deed of extrajudicial partition which included all the lands that were covered by the 4 deeds of sale that were previously executed by Alfonso for taxation purposes. After their father's death, the heirs of Policronio found tax declarations in his name covering the 6 parcels of land, believing that the 6 parcels of land belonged to their late father and as such, excluded from the deed of extrajudicial partition, the heirs of Policronio sought to amicably settle the matter with the heirs of Alfonso. RTC ruled in favor of the heirs of Alfonso in a decision, and the CA affirmed the finding of the RTC that the deed of sale was void. The court is confronted with an issue of whether or not the deed of sale was valid. Ruling: the court finds no cogent reason to deviate from the finding of the CA that the deed of sale is null and void for being absolutely simulated. Article 1345 provides that simulation of a contract may be absolute or relative. The former takes place when the parties do not intend to be bound at all, the latter when the parties conceal their true agreement. Article 1346 states that an absolutely simulated or fictitious contract is void. A relative simulation, when it does not prejudice a third person and is not intended for any purpose contrary to law, morals, good customs, public order, or public policy, binds the parties to the real agreement. Thank you for listening. Hope you learned something.